Good afternoon, everyone. I am Kylie Vandevi Andino, and I will be discussing previous conduct as evidence, specifically evidence of other bad acts in sexual assault cases, and the difference between habit evidence and character evidence. So, the inquiry that we have to answer in relation to previous conduct as evidence is whether or not previous conduct may be admitted as evidence. For instance, when a person has been convicted of, let's say, theft for 3 times, would such conduct or conviction be admissible to prove that he did the same thing at another time? Or, for example, when a person has been rehabilitated in an institution for more than 3 times for excessive drinking of alcoholic drinks. Would that conduct or fact be admissible to prove that he did the same thing at another time? Now, the rules of court provide such answer. According to the rules of court, evidence that one did or did not do at one time is not admissible to prove that he did or did not do the same or similar thing at another time. So we could say that previous conduct is irrelevant to the current controversy. However, under the rules of court, there are exceptions to the general rule where previous conduct may be admitted as evidence, but only to prove a specific intent, knowledge, identity, plan, system, scheme, habit, custom, or usage. Now, another exception is evidence of other bad acts in sexual assault cases. In the case of United States versus Lecomte, Lecomte, or the respondent, was charged with sexually abusing the of his wife's 11-year-old niece, which is CD. However, the evidence which was submitted by the government were irrelevant. The evidence that they submitted were sex offenses committed by Lecomte against another niece of his first wife, which is TP. So the Supreme Court or the court here uh, acknowledged that although the evidence only relevance was as to the propensity to commit the child sexual abuse, the rules of evidence expressly allowed this, which is according to the rule of evidence in a criminal case in which the defendant is accused of an offense of child molestation. Evidence of the defendant's commission of another offense of child molestation is admissible and may be considered for its bearing on any matter to which it is relevant. Now, moving forward to the case of Reyes versus Missouri Pacific Railroad Company, the court here differentiated the difference between habit evidence and character evidence. The controversy here was whether or not the evidence of 4 prior misdemeanor convictions of plaintiff for public intoxication for purpose of showing that he was intoxicated at the night that he was run over by defendant's train should be admitted. The rule of the court here that it was admissible or inadmissible rather. The court first differentiated the difference between habit evidence and character evidence. According to the court here, habit evidence is considered to be highly probative. Therefore, it is superior than character evidence because the uniformity of one's response to habit is far greater than the consistency which one's conduct confirms to character or disposition. Although habit evidence or habit is quite similar to habit, character is a more generalized because it is a generalized description of one's disposition in respect to the general trait, such as honesty, temperance, or peacefulness. However, habit is um, more specific. It describes one's regular response to a repeated specific situation. So there is no formula in determining whether behavior may become so consistent as to rise to the level of habit. But the primary consideration, according to the court, is the adequacy of sampling and uniformity of response. Thus, the probative force of habit evidence to prove intoxication on a given occasion depends on the degree of regularity of the practice and its coincidence with the occasion, which is not present in this case. Now, in People versus Darton, defendant robbed and killed his employer Paul. Paul was to pick up his friend Gardner when the unfortunate event happened. The petitioner offered evidence of three telephone conversations which Paul had with Gardner, during the course of which Paul indicated that he was waiting at his shop to receive payment on a loan that is made to unidentified individuals, and in fact that he had received word that they were on Interstate Route 890 in close proximity to the shop. Now, people or the petitioner also offered testimony by Gardner and Paul's wife concerning Paul's habit of carrying large amounts of cash on his person, particularly when on a business trip. Now, the issue here was whether the lower court erred in receiving the evidence concerning Paul's habit of carrying cash on his person. The court said that no, it has long been the rule that the evidence of habit is generally admissible to demonstrate specific conduct on a particular occasion. Under the state of mind uh, hearsay exception, when a particular act of the declarant is at issue, the declarant's statement of a future intent to perform that act is admissible as proof of declarant's intent on that issue and as inferential proof that the declarant carried out his intent. Secondly, as a further extension of the species of the state of mind exception, courts have admitted statements of a future declarant's intent to perform an act with another person as circumstantial proof that the act did occur and by necessary implication that the other person participated in the act. Finally, the exception has, under appropriate circumstances, been applied in cases where the third party non-declarant is a criminal defendant and evidence of the defendant's participation in the act sought to be established tends to inculpate him in the charged crime. That would be all. Thank you everyone for listening.